Hey everybody, what's going on? This is close to the end of our time together for skills. This is Nate, and today we're going to go over evidence and rule explanation. Um, I want to just let me make sure you guys can hear me well. Yes, it looks like you guys can hear me. Hold on. All right, cool. So audio is working fine. There are no last time we did have some audio issues, so hopefully that has been solved. All right, so what are we doing today? Today we're going to be going over the assignment in lieu of class for evidence, and it's for in lieu of class 24. Now it's on the twin site for the professor, so if you guys want to read along with me, you guys can. We're going to be going over the first essay, and I'll see if I can get how much of the second essay we can get through within this hour. Next week, we're actually going to be going over last year's final exam next Sunday, so you guys should be aware of that. What do I want to start with today? So today, we're going to be going over essay 1, and specifically, we're going to be going over the rule and rule explanation. And most of this week, I've been seeing students for an hour at a time. If you guys want to also schedule time with me, I'm on a one-on-one basis. I sent out an email with the schedule. There's plenty of slots still left open. Just send me an email and pick one of those time slots, and I will be available, and I'll be here for you. I'll be talking about evidence or constructs or whatever you need to talk about. So today, we're looking at rule and rule explanation from the assignment in lieu of class 24. If you guys also have any questions that you guys would like to ask me, you guys can put it in the chat. I'm also going to be looking at the chat. So hello to everyone out there. Okay. So first, let's talk about this assignment. Now, I'm not going to read the facts of the assignment. We're just really going to go straight into what the professor has given us as a model answer. And the professor has given us a lot of information. We're going to go through it. And some of this you'll see that I've already have pulled out what the rule and rule explanations are, and some I haven't, because I'm going to show you the process in which the way I actually do it. So you can try it on your own for the next assignments or for any other explanations or any other examples the professor gives to help you guys pull out the rule and rule explanation. So let's just get into it. So first, this is the first essay, and this is the first issue from the professor's model answer. And this is the issue. The issue is whether the witness claiming lack of memory at trial can be impeached with her prior inconsistent statement, and whether the evidence was overly prejudicial. So we have two issues here. We have overly prejudicial, and we have one where can we get the statement in? That's a prior inconsistent statement. So I looked at let's look directly at the rule. And that's what you're seeing now on your screen, what the rule is. So when you're looking at these, I haven't actually changed anything from what the professor had. I just broke it down into this bullet form. So this was her rule. Any party may impeach a witness, even a witness they called. This is the second sentence. A witness has made a statement and then makes an inconsistent statement. The witness may be impeached with the prior inconsistent statement. So all of this is actually the rule, A and B. And again, I haven't changed any of the wording. I just separated the two sentences. Now, prior inconsistent statement. This wasn't here. This is something I added because here is the definition of prior inconsistent statement. Claiming lack of memory or making vague statements are considered inconsistent statements. So in that first little paragraph that the professor has, she's done a couple of things. The professor has given us the rule for impeaching a witness for prior inconsistent statements, and then defined what prior inconsistent statement is. So that is the first part of the rule. Now, there are no numbers for the FRE in here. It's just, this is the understanding. So this is not a direct copy and paste from the actual Federal Rules of Evidence. This is how the professor understands the rule and has given us an understanding of what prior and consistent statement is. And here has actually elaborated on what it is. So in using this rule, now you know what the model rule is that you should be trying to put forward on your exam. So let's look at the rule explanation. The rule explanation for this rule for prior and consistent statement is impeaching a witness provides evidence the jury can use to assess the witness's credibility. So that's the rule explanation, and here is the rule. Now, going down to the next piece. It says if a party is being questioned about a prior and consistent statement, the person questioning them does not have to show the statement to the witness, but if requested, must provide a copy to opposing counsel. So this is a process rule. This is what you must do if you're going to be doing that. Again, this is separate from the rule explanation, but this is what you must do. The next part of the rule. If the prior and consistent statement goes to a material or non-collateral matter, a party may admit extrinsic evidence other than the testimony of the witness on the stand to prove the prior inconsistent statement. Now, there's an issue here I should note. Here, extrinsic evidence is in parentheses, but this is actually defining what extrinsic evidence is. Now, I'm going to ask the professor whether you have to make this clear that you're defining extrinsic evidence, but it's here defined as evidence other than testimony from a witness on the stand. But the fact that it was in parentheses, I'm not sure if the professor is going to require that you actually define extrinsic evidence. But here it is defined. Here it's defined, but in parentheses. So to be safe than sorry, I would say define it, and here's the definition. Now, what was defined was material versus non-material. And here's what the professor said. A material or non-collateral matter is something that goes to a fact of consequence in that matter. So this is actually clearly defined. So what is defined is what is material or non-collateral. Material and non-collateral are synonyms. They mean the same thing. But it is specifically defined within the professor's model answer. That is defined. So for this particular rule, you must mention, even though we're not too sure about extrinsic evidence, you must define what a material or non-collateral matter is within your rule. And then the last piece of this rule, if extrinsic evidence is admitted to impeach the witness must be given an opportunity to explain the prior inconsistent statement through although the opportunity can be on either cross or direct examination. So again, that's part of the process. But here, really the only piece of rule explanation we have is here about impeaching a witness. But here we've looked through the rule. We see we have a couple of different pieces of the rule. We have some terms that have been defined within the rule. And this is what the professor has given us as a model rule that we should be using if the situation was to come up again, prior inconsistent statements and impeaching a witness based on them. Now, I know this is a lot, but this is the way we should trying to break down the professor's model answer so we can just get a better understanding of the rule. And on top of that, there's another piece of it here too, is that we now have a better understanding of what this rule of what is acceptable rules that the press is going to accept on the exam. Again, these rules aren't copy and paste from the federal rules of evidence. They're the professor's understanding of the substance of the rules. Now, if these seem more comfortable to remember, I think you'll be okay, because this is what the professor's saying is a model. It's a model answer. Any questions? No questions. So going on to the second piece of the issue, whether admitting the prior inconsistent statement for impeachment purposes is, well, again, we have the rule and rule explanation. So here's the rule. Under 403, evidence may be excluded if the probative value of the evidence. So this is the rule for 403 laid out. Boom. And now the rule explanation for 403. 403 is a high bar to exclude evidence, as the court wants to provide jurors with as much relevant evidence as possible. There is a thumb on the scale for admitting evidence under 403, and trial courts have substantial discretion in their 403 determination. So here's a rule explanation understanding the policy. It's, we're generally going to be allowing evidence in, and here again it tells you that the trial courts have a lot of discretion. So we have a clear rule explanation, and then we have a rule for 105. If requested, the court must give a limiting instruction explaining to the jury they can use the evidence for one purpose and not another. The system depends on jurors following these types of instructions from the court. So again, here we have, for the second piece, whether admitting it is overly prejudicial, that triggers 403. And here we have our 403 determination. And then we have a 403 analysis here, which I hope that you guys look at to see, because a lot of students have been asking me about 403 and how best to apply 403. So here's your 403 analysis right here. So now let's move to the next issue, which is whether the witness's prior identification of the defendant is admissible to prove the witness saw the defendant, was in the park. Now, again, as we've been breaking it down, what piece of it's the rule? What piece of it is the rule explanation? So from the professor's model answer, here's the rule for this: hearsay. Now this is a clear, concise rule for hearsay. Hearsay is a person's out-of-court statement or written statement or nonverbal conduct which is meant to communicate a fact which is offered to prove the truth of the matter asserted. Now, usually when we say hearsay, we will say an out-of-court statement offered for the truth of the matter asserted. But here, the professor's already defined what statement is within the rule. So hearsay is a person's out-of-court, and what you see here, oral, written, or nonverbal conduct, that's all statement. But instead of saying statement, the professor's listed out. So now I would suggest you use this, because if you do use an out-of-court statement, you would then have to define what statement is. But the professor here, as a shortcut, defined it within the rule, which is acceptable. So now we don't have to define what statement is in the second piece. It's already been defined within the rule. And then for the second part of the rule, hearsay is inadmissible unless the statement satisfies an exception or exemption. So here we have what hearsay is, and the fact that it is not admissible, the general prohibition against hearsay. Now here's the rule explanation. This is because without the ability to cross-examine the declarant, the statement's reliability cannot be tested. So we have the rule, and we have the rule explanation of policy and why we exclude hearsay. Now, we have another rule, a separate rule. Now, this is the trial court determines whether a statement is hearsay pursuant to Rule 104 and does so not bound by the rule of evidence except for privilege and based on a preponderance of the evidence standard. So again, that's a very short and concise rule explaining how hearsay and Rule 104 works. Then we go to Rule 801D. I think this is, sorry, it's D10. I think this is wrong. D1C. Now we have the general rule for hearsay. We have the rule explanation for hearsay. We have how courts determine whether a statement is hearsay pursuant to 401. And now we have the specific hearsay exception or exemption that we're going to be talking about. And here, this is a witness's prior statement of identification of a person made after perceiving the person is exempt from the hearsay exclusion and can be admitted for the truth of the matter asserted if the witness who made the statement testifies at the trial and is subject to cross-examination concerning the statement. Then the professor goes on to define cross-examination here. What is cross-examination? It's a witness is subject to cross-examination if they claim memory loss, a witness is subject to cross-examination even if they claim memory loss, because they can be questioned about the extent and cause of the memory loss which can be useful to a jury in determining the credibility of the evidence provided. So here we have the bar against hearsay, we have the exemption 801D1C, and we have subject to cross-examination. We have cross-examination, which is now defined here. A witness is subject to cross-examination even if blah, blah, blah. And then we have the rule explanation. And as you'll start seeing going forward, the rule explanation goes forward and starts saying the rationale. And here it is. The rationale for the rule is that prior identification is more reliable than one made further away from the time when the witness saw and identified someone. So here, again, if you're struggling with how to put rules together or how to understand how best to describe these rules on your exam, you have here a template in which the professor is giving you different methods of explaining these rules out. For instance, hearsay. Hearsay, instead of saying there's an out-of-court statement or for the truth, we're saying, hearsay is a person's out-of-court oral or written or non-verbal conduct. Again, that's synonym for statement. And here you also see the rule explanation, what the professor is pointing to, what the professor is defining. So there is no question on what you should be defining in your particular rule and rule explanation. Now, the next issue on this one is, are witnesses out-of-court statements that saw the defendant strike and rob the victim admissible as proof the defendant did attack the victim? So the first thing is, I want you to notice here is that the professor puts see rule for hearsay above, because we're talking about hearsay again, and you don't have to waste time and rewriting a rule that you're going to be using again. So it's appropriate to say see rule for hearsay above, but you do run the risk that that rule may not be right. So you should make sure that rule, if you're going to be using it again, is correct, because now, the rule is wrong up at the top, it's going to be wrong here again. So you don't want to just lose points for sloppiness, especially if you're going to be reciting to rules. So just make sure your rule is good. And again, we go straight to the analysis. This has saved us a lot of time than to retype out the rule for hearsay, because it's already there. So we've saved all that time. And now, especially for you slow typers out there, you guys now have a method of saying, okay, see rule above. But again, you do run the risk. If the rule above is bad, then this rule is going to be bad, and you're going to be losing double the points. Now, here is the rule and rule explanation for prior inconsistent statements, the exemption. Now, for this, it says, for a statement to be exempt from the hearsay rule, a prior inconsistent statement under there's the section. Now, remember, before the professor said you didn't really need to know the section. These sections are in here for illustrations, but you don't have to actually know the number and the precise lettering of the rule. You just have to know the rule. And be admitted for the truth of the matter asserted, not just to impeach the blah, blah, blah. It must have been made under penalty of perjury at the trial, hearing, or the proceeding, and must be inconsistent with the declarant witness's trial testimony. So here is just laid out what the rule is. This is the rule. And again, if you're having problems with wording the rule or understanding how the rule works, this is a good way to see the rule in plain English, see the rule how the professor understands the rule, and try to mimic the same response. And part 2 of this rule is the declarant witness must be testifying and subject to cross-examination. Again, this is a critical piece of the rule. So this rule has 2 parts, and we've just now understood how the professor understands these 2 parts. And again, here for a statement, again, when we're talking about a hearsay and what a hearsay statement is, it's been defined up top. Remember, instead of saying statement, we actually went through and defined oral, written assertions, and so forth and so forth. So now the rule explanation. Again, hint, hint, the rationale behind the rule is, and again, you're going to start seeing that common theme within this professor's understanding, is that the rationale behind the rule. So here is a clear slap in the face of this is the rule explanation, the rationale behind the rule, is that requiring the out-of-court statement be made under penalty of perjury at a trial-like proceeding helps ensure reliability. Because again, when you're talking about hearsay, we're talking about reliability, and that because the declarant witness is testifying and subject to cross, the jury can actually assess their credibility directly. So this is telling you why we believe this is reliable. We're saying it's reliable, and this is the reason why it's going to be reliable. So again, if you're having problems trying to understand how to describe these rules on your paper, because I've been getting a lot of the one-on-one sessions that I've been having with students. Again, if you guys want to have a one-on-one session, please, we can do it through video conference, we can do it over phone, or we can do it in person. Just let me know, send me an email, we will do it. But what you're seeing now is that this is a different way of not only understanding the rule, but also putting it down on paper. And I think you guys should be typing these rules out. You guys should not be the first time you type this rule out shouldn't be on the exam. You guys should be typing these rules out, getting used to how these rules flow and what all this means. And if you would like, just to make sure the professor's clear, because the professor identifies this as the rationale behind the rule, you should also be going into this is the rationale behind the rule. That will signal to the professor that you're talking about rule explanation. Or you can just put rule explanation. Like I used to, when I was a student, I put rule explanation and then put what it was. But here, if you don't feel comfortable doing that, you could put the rationale behind the rule, and it would trigger the professor to understand that you're talking about rule explanation. So now, here's one that I didn't break down, and there's a couple of them that I haven't broken down before. And I wanted to show you guys the process in breaking this thing down. So if you guys get other model answers or anything like that, you guys can start breaking this down yourself and seeing, okay, here's what the rule says. Here's how, here's what got all the particular credit. Because earlier, actually for the past couple of days, a couple of students have been saying they've been going over this and they just couldn't pull out the rule explanation like I've been doing now. So this is just a technique so you guys can see me actually pulling out the rule explanation. So so if you guys see any other model answers or anything, you guys can just start doing this yourself. And it's really not that difficult, but this is just a process to help you guys see what my thinking is. So here, the rule explanation. Now, we can read the issue, but to the judge, I have admitted testimony of the police officer and defendant about being arrested several times in Central Park. Okay, so this is about character evidence. So first, we talk about character evidence is generally inadmissible to prove. And so this is the rule for character evidence, in particular with wrongs, blah, blah, blah. We go to the end of the sentence. So I'm just taking that out because I'm reading this. Character evidence is generally inadmissible to prove a person acted in conformity with a particular character trait. And evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with that character. Boom. That is FRA 404, the prohibition against character evidence. So I'm going to type here, RULE. That's the rule. And we can put rule 404, but now we know for sure that's the rule for character evidence that we're going to be leaving. Not too long, one sentence that's about one sentence, and it's a pretty long sentence, but it's just one sentence. Here, the rationale behind, the rationale behind, boom, let's put rule explanation. So this is our rule explanation. The rationale behind the prohibition of character evidence is because jurors often overvalue and overweigh character evidence, and because people often do not act in accordance with their character. Therefore, jurors' use or reliance on character evidence can be highly prejudicial. So we've taken out and we've understood now. Here's the rule, and here's the rule explanation for character evidence. This should be, bell should be ringing. Okay, so if I understand this piece and this piece, I understand both the rule and rule explanation. As you can see from this piece of the document, there are no FRE numbers in here. This is just an understanding of what the prohibition of character evidence is and what the rule explanation is. Now, this next piece, let's read it together. However, evidence of crimes, wrongs, and other acts that may seem to be character or propensity evidence can come in for other reasons, such as providing motive, opportunity, plan. This evidence must be proffered for the purpose must be proffered for a purpose other than a forbidden propensity inference. It must be relevant. It must be relevant to be proffered to the proffered purpose. It must survive a full through balancing test. Okay. So now we're getting a little bit more into, it seems like, rule. So this is another rule, and this is still 404. Let me just make sure this is 404B. And this is rule 404B. Where this was rule 404A, the prohibition. So here, rule 404B, and this is telling you that we can use character evidence as long as we use it. We can't use it to show propensity, but we can use it for some other purpose. And it lists out those purposes, right? Then it lists out how the evidence must survive a fourthly balancing test. Then it says, finally, in criminal cases, you got to provide reasonable notice. Again, this is back to 404. And when deciding on whether or not the evidence is admissible in criminal cases, similarity between crimes. So this is now, if you're bringing it in, you got to consider these factors. Other acts and crimes charged when the profit purpose is something like intent, planning, knowledge, or whether the other act or evidence has some direct connection to such as providing motive, intent, or knowledge of the charged crime. So this is a long rule, and it's interesting because there's something I don't see here. I don't see the rationale, the rule explanation. It doesn't. I don't see it here for 404B. And I'm just looking at my notes because I'm just trying to see if I see it. But if you guys see it, let me know. But I don't see the rule explanation. I was looking for it, but I don't see it. I'm just making some spaces here. So, okay. So here we have the 404B rule. We have how to present it, right? And it has to go to 403. We have the exception for criminal case. And if criminal case, you got to give notice. Then we have when the court is deciding whether or not other acts evidence is admissible in criminal case, and often is considers, and it gives you kind of what it considers. One, similarity between other acts and the crime charged. When profit purpose is something like intent. So, okay, so yeah. So this gives you the process, but again, here we don't really have rule explanation, or we don't have the rationale behind this rule. We don't have those words. So when we're talking about character evidence, this is a pretty long rule because we started here with 404A. We started for the rule explanation for 404A. Then we went to 404B, and we started with the rule, the exceptions, the exception for a criminal case, and then the other things that we have to address when it's admissible in a criminal case. So all of these things have been encompassed here, and this happens to be a larger rule, a little longer rule. But now you guys see what's expected if you had a similar question dealing with character evidence. So this is two rules that are really fleshed out and everything that you must address if you're talking about this particular subject. And here is the analysis. And you see 404B2. So we've now looked at two rule explanations. We've looked at hearsay. We've looked at character evidence. We've looked at prior inconsistent statements. We've looked at we've really gone through a whole bunch of the rules. Impeachment evidence. We've looked through a whole bunch of the rules, and we've now started to see what the professor's been looking for when we're describing the rules and when we're looking at the rule explanation. We've also seen when, for instance, hearsays come up again twice, and we've seen that we don't need to reread out the rule, but point to the rule above, and that's going to save us some time. And again, we've looked at rule and rule explanation, the rationale behind the rule. And we've also learned how to identify or trigger a rule explanation by allowing the professor to know what we were talking about by saying the rationale is. So now we're going on to the fourth issue in the first essay, which is, was Buddy's testimony about the defendant being gentle, honest, and returning the wallet admissible? So again, this is going to be the last one we do. Then I'll leave essay 2 to you. I'm actually going to send out this document that is already prepared. It's going to have all these things broken down, so you guys can see them broken down, all the rules broken down that are on this page in those separate particular chunks. So if you want to just study from these rules, or if you want to put the rules in your own words, this will give you a nice little template to see what the professor's looking for, which is probably going to get you all the points on the exam. So here we're going about whether Buddy's testimony about the defendant being gentle, honest, and returning the wallet is admissible. Okay, so that's character evidence. So character evidence is, so this is more or less a copy and paste, right, from the top. Character evidence is generally inadmissible to prove a person, boom, 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 boom. And see rule above. That's exactly what that is. 2. However, the mercy rule. So now we're talking about another piece of the rule, the mercy rule, which was not see above. So we have to define it. A mercy rule allows the defendant to, in a criminal case, to offer evidence of their own pertinent character trait. So we're talking about the mercy rule. This is to provide the criminal defendant with as much leeway as possible in putting on their case. Well, hold on. In this rule, seems like we got a little policy snuck in here without those magic words, the rationale. Boom, that's a rule explanation, it looks like to me. Explaining why this rule is important. It's to provide criminal defendants as much leeway as possible in putting on their case against the best resource state. That is the reason why we have this mercy rule. Now, it goes on. Now, this is a longer rule. The defendant is limited to proof of pertinent character traits, often defined as relevant traits, although many judges require a slightly heightened relevance plus standard regarding more direct connection between the charge or the defense or the prosecution's theory of the case and the proffered character trait. If the defendant does admit pertinent character trait, they can do so using reputation and opinion evidence. So this is methods of proving character. And if the defendant offers such evidence, the prosecution can rebut, right? Yeah, this is on cross-examination. The defendant's character witness may be asked. Let me see. If the defendant offers such evidence, the prosecution can cross-examine the defendant's character witness by asking about relevant specific instances of conduct. Again, this is Rule 404. Once the defendant has opened the door by offering character witness, either as a defendant or the victim's pertinent character trait, the prosecution can also call their own witnesses but must match the character trait raised by the defendant. Or if the defendant asserts a specific character trait of the victim, the prosecution can call character witnesses to testify, again, representation and opinion only, to rebut the defendant's or show that the defendant shared the same character trait. So here, this is a lot of rule. This is all rule. This is all rule. So here, we have the rule explanation here, like a one-sentence thing. But all of this is rule. All of this is rule. And exactly, and this is also explaining to you methods of proving character, reputation, and because if you look at Rule 405, now, well, yeah, 405, it's about methods of proving character, but this is it's actually encompassed in Rule 404 also. But these are methods of proving character. The defendant, if the defendant's going to put character evidence on, it's got to be about reputation and opinion. On cross-examination, you can ask about specific instances, but remember, you're stuck with the answer, and so forth and so forth. So this is showing you how the mercy rule works, but again, this is showing you the full rule. So this is a lot. This is a lot. But again, this is the things that we need to understand. What the professor's looking for, which rules have a rule explanation involved with them, which obviously this one does, and when one is lacking. Because in this particular one, for the mercy rule, there is really no rule. There is no policy behind it. The only general policy, is that this provides the criminal defendant with as much leeway as possible in putting on a case against the better resource state. So that may be the policy for the whole general rule. But again, you see, it's a one-sentence policy where the majority of all of this text is actual rule. And again, look at it yourself. And if you feel like this is too wordy for you, or you feel like you can word it better, or you feel more comfortable using the rule in the Federal Rules of Evidence, you can use that. But again, this is how the professor is thinking about how the rule. This is how the professor understands how the rule works. These are her words. Now, the fifth one, we're really not going to be doing it because I looked on the sheet, and this is about appellate review, and it is not on our sheet. So I don't want to even go through it because I think it'll just confuse people and it'll just add unneeded anxiety to the process. So we're not even going to look at that because I looked on the sheet. I'm looking at it again just to be sure, but it didn't seem like we're going to be doing anything about standards of review and appellate review. So we're not even going to look at that. So as you can see here, what I've done is that we've now looked through the rules, we've looked through the rule explanations, seen how the professor understood the rules and rule explanation, and now we're going to make it or concluding that, whether you're going to go with the professor, how the professor understands the rules, you're going to be going with how the Federal Rules of Evidence understand the rules, but this gives you a little leeway into how you're actually going to study the rules and put them on the page. And this also gives you policy for if you guys were confused about any policy for any of the rules that the professor used, you have them here. You can see the policy. It's laid out plainly. So this document you'll have later today. I'll have them both. I'll have all the rules from these two documents laid out with the rules and rule explanations that the professor provided, so you can just see them in isolation. And then we'll talk about later on this week, we'll start talking about how they were applied during this particular I was about to say exam, during this particular exercise. Now, there are a couple of things I want to mention before we end this today. The first thing I need you guys to realize, and I'm going to start typing here so you guys can see what I'm typing, but there are a couple of things I need you guys to really understand. When we're talking about here in evidence, the rule explanation is just policy. And why is that important? Why do we need policy? Well, especially when we're talking about our 403 balancing test, it's how we're balancing. It's the seesaw that's balancing the policy. For instance, we're going to have the probative value of why we're letting this particular evidence in. And as we can look back to subsequent remedial measures and say, if something is being let in as a subsequent remedial measure, it could be let in for something different, let's say for ownership or control. So if we're letting a subsequent remedial measure in for ownership or control, that's the probative value of why we're letting it in. But the prejudicial effect is going to be against the policy. The policy that we don't generally allow subsequent remedial measures in is because we want people to fix things. We want people to repair things and not be held liable for, not that evidence not be used against them to hold them liable for someone getting hurt. We want people to fix things. So that tension between the admissibility of bringing the subsequent remedial measure for something else, let's say for ownership or control, versus the tension of forwarding the policy of keeping it out because the jury may use it to say, okay, well, even though we know you're only using it for ownership or control, but since you fixed it, that means you broke it. And that's what we don't want the jury to say. So that tension between those two is the tension that we're looking at 403. The probative value of, it's showing ownership or control, which is great, but then we have a high prejudicial value of the jury actually using it for an improper purpose, which would be for culpability. And since 403 has its thumb on admissibility, more likely it's going to be admissible or not. And when you do those evaluations, you're really doing the evaluations whether allowing this evidence in is going to further the policy goals of the court or it's going to work against the policy goals of the court. And that's the balancing test we're doing with 403. And you'll see that when you look at this example. Well, listen, guys, again, you see my schedule. I'm here in the evenings for you. You can just sign up for the times. I'm also in school today. I've been here since the morning. Some people I've had I think 2 or 3 meetings early this morning, hour meetings. I have a couple of video conferences later today. So I'm here for you. We're going to be going through this week. I'm going to be putting up this document. I'm going to put up a family law document. So we're going to be really, 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 grinding it out for the next 2 or 3 weeks to make sure you guys get the best possible grade on these exams. I hope all is well, and thank you for watching. This video will be up, and this document will be to you later this evening. So my name is Nate, and thank you for watching this skills presentation, and I will see you guys a little bit later.